Honourable members, let's pray. Almighty God, we humbly beseech thee to look with favour upon this Parliament of Ghana. Grant that it may perform its high duty aside. Give divine guidance to the President of the Republic, endow members of Parliament and Ministers of State with discernment and vision, integrity and courage, that through the labours of government, this land and people may be well and truly served, and thy good purposes for the common human life be realized in our midst. O God, grant us a vision of our country, fair as it might be, a country of righteousness, where none shall wrong his neighbor, a country of plenty, where evil and poverty shall be done away with, a country of brotherhood, where all success shall be founded on service and honor shall be given to the deserving, a country of peace, where government shall rest on the will of the people and the love for the common good. Bless the effort of those who struggle to make this vision a living reality. Inspire, strengthen our people that they may give time, thought, and sacrifice to speed the day of the coming beauty of Ghana and Africa. Amen. Honourable members, per the new standing orders, we will move to item 2 in today's order paper. That is roll call. I will ask the table to quickly. Yes, Honourable Member for Okanekwe Central.
Thank you, Mr. Speaker. Mr. Speaker, much as I respect the House rules, I believe that this sort of check-in attendance must be used sparingly, Mr. Speaker. If it becomes a daily feature, and we come in and sign, and another member comes in and is marked absent, every day we'll be going back and forth. We must test the rules well. Yesterday it was used. Today members have the role of attendance. I believe it will send a message to the public about members' attendance to work on the floor of the House. Mr. Speaker, I believe we must be very careful with how we apply this rule. The rules gives you the discretion, but that discretion must be used not to hurt members of Parliament. Mr. Speaker, this is an election year. The public is watching every activity in the chamber. Members may be in committee as early as 7 a.m., 10 a.m. We've been sitting here from 9 a.m., Mr. Speaker. The House just at 11. I have a committee meeting, but for this, I would have been in the committee meeting, Mr. Speaker. So we have to be very, very careful with this rule, Mr. Speaker.
Well, Honourable Member, I think yesterday we discussed this thoroughly, and Mr. Speaker highlighted the 3 steps: the roll call, even the registering of members in the normal register. I mean, we are doing all of them concurrently, but at least my view today is that this week, let's focus on call. After next week, we can decide as to whether we will use our discretion. But for now, I want us to go ahead with the new standing orders. So, roll call. Table, please, let's start.
Abaka Samuel Erickson.
Leader.
Yeah. One issue was raised yesterday. I think it's important we also raise it here. There are members who are absent because they have been permitted. They are absent with permission. And it is important that, for example, the clerk at table who already know members who are absent with permission. When we get to their turn and they are absent with permission, it has to be announced that this member is absent with permission. It's very, very important.
Honourable members, if a member is absent on permission, it is already on record. The person has received permission. So it will be captured that that member was absent on permission. So I don't think there's any issue on that. Honourable members, my rule is that we should go ahead with roll call.
Mr. Speaker, I just rise to seek guidance from you because, Mr. Speaker, in as much as we are members of Parliament, you would always guide us when it comes to this thing. Mr. Speaker, this is a live telecast of the proceeding. Live telecast. I just called Honourable Jaja. He's at the Roads Committee serving Parliament. Mr. Speaker, in such a situation, Mr. Speaker, how do the conference do that indeed? And maybe then you may want to rule that when they're reading the names, those who have permission from you, they should mention that Mr. A has indeed asked for permission from you and is unavoidably absent. So that it's on record. Thank you.
Honourable member, we discussed this yesterday at length. The decision is that the new rules covers roll call. The speaker may have his discretion, but today my position is that the roll call must go on. Table, let's move ahead.
Abaka Samuel Erickson.
Present.
Abanga Abdullahi Jacob Idris. Abdul Latif Dan. Abdul Salam Adams. Ablaka Samuel Okujeto. Abuaji George Kwame. Abuaji Kwejonyampo. Abudulariba Zurewa. Achampon Brian. Achampon Charles. Achampon Richard. Akwaku Sophia Karen Edem. Akwa Alexander C. Adam Hamza. Adam Mohammed Amin. Adams Kofi Idi. Teddy Safori. Ado Yao Frimpong. Ejay Kwesi Boateng. Adum Frederick Obeng. Aduma Mensa Alex. Adumako Mensa Collins. Adongo Isaac. Edu Johnson Kweku. Edu Chumiao Osei. Afenyo Markin Alexander Kwamena. Afol Eric. Efri Famen. Alauzuga Alpuka. Alasan Abdallah Idi. Al Hassan Bashir A. Husseini. Al Hassan Lydia Seyram. Al Hassan Taibu Suhini. Aliu Mahama Umar Farouk. Alote Angela Oforiwa. Amankwa Nicholas. Amankwa Kofi. Amewu John Peter. Amiao Tremikwesi. Amwa Oseibonsu. Amwa Stephen. Amwaku Andrew Esiama, Amwaku Atakwesi, Ampim Thomas Nyako, Ampofu Chumesi Kwame, Amprechum Saponkwe, Andre Emmanuel Ejay, Enim Ernest Yao, Enim Moses, Anodom Pre Frank, Entry you Wache, Animedu Entry Kwame, Apak Clement Abbas, Apia J Patricia, Apia Kubikwa Andy Kwame, Ama Prince Hamidu, Asamo Vincent, Asante Kwejo, Asante Boatin Kweku, Asensu Boachi Francis, Esiama Isaac, Esiama Kwabna Mankwa, Esiama Ejay Nanama Dokua, Asafo St. Echo, Samuel Samuel, Aveji James Kluje, Avoka Cletus Apu, Ewa Ignatius Bafo, Awuni Teresa Ladi, Ayamba Ladi Ayi, Ayarga Mahama, Ayiku Benjamin Nate, Ayine Dominicaga.
Mr. Speaker, our rules are clear on defection. When you cross carpet, resign as a member of parliament. They mention the name of Honorable Ayaga. He's sitting by me. We need clarity as to whether he has crossed carpet. That's made me a courtesy call.
Mr. Speaker, he is the chairman of a committee to examine one of my petitions. So we're just discussing the matter of the petition.
Berefi Michael Ochre, Baba Benson Tongo, Baligi Bright Bachi Yilib, Bandim Azuma Abednego, Bano Patrick, Batel Sheila, Bawa Edwick Abba, Bedra Emmanuel Kwesi, Bettino Joseph, Blanc Boachi Henry Yadom, Boachi Yadom Patrick, Boama Patrick Yao, Ni Akwesi Daakon, Boatin Amapom, Boatin Joseph Apia, Bobie Ivan Sopoku, Boche Daniel, Brahima Muhammad Bawa, Boa Emmanuel Amakofi, Bukari Joseph Nipe, Chinya Amidu Ishaku, Chirajia Songbumbu, Chiwete Andrew Dari, Krensola Babe, Kujo Comfort Doyo, Kujo Joseph, Kujo Robert Wisdom, Kujo Robert Wisdom, Dafiamapa Roxy Nelson Echekme. Dalu Thomas Ada. Dapila Kletu Seiju.
Present.
Dako Daniel Ohene. Da Kumensa Kwabna Oye. Dauda Collins. Dawuni Abukari. Derry Ambrose. Jonobwa Alex Tete. Douglas Morris. Donko Kwabena. Duka George Mreku. Eyanana. Forger John Intim. Forsen Castle Atuban. Frempong Gape Kwame Jujoli. George Samuel Nate. Ganza Al-Hassan Kobna. Gate Joe. Gidisu Wisdom. Gomado Yao. Gomashi Ablajifa. Jenfi Emmanuel Akwesi. John Alexander. John Mensa Richard. Hammond Kwabna Tahir. Hansen Norte Yves. How say you? Hayford Ophelia Mensah. Otto J. Alexander Roosevelt. Ibrahim Ahmed. Ibrahim Mutala Muhammad. Ibrahima Zureba Muhammad. Idrisu Habib. Idrisu Haruna. Isifu Seidu. Jaban Benham. Jaja Yusuf Isaka. Jalula Stephen Hambin. Joshua Godfrey Seidu. Jinapo John Abdullahi. Jinapo Samuel Abdullahi. Jeffrey. Kisi Dixon Adomako. Kunaidu Akwesi. Kumsin Mavis Howard. Kosa Martin Kweku Ejay Mensah. Kodo Benjamin Komla. Kum Ebenezer Kojo. Kuma John Ampotwa. Kuma Joseph Kwame.
Present.
Huyon Solomon. Kwachi Akapita Yao. Patin Kweku Ajeman. Kofi Festus Ewa. Jay Mensah Bonsu Osei. Tremi Nelson. Labi Oscar Ofori. Lati Agnes Namumu. Liwal Oscar. Mahama Asiesini. Mahama Nasser Toure. Mabel Francis, Marfo Emmanuel, Marfo Kofi Ahinkra, Mbomba Thomas, Mensa Betty Nanefua Crosby, Francisca Otain, Mensa Isaac Ajay, Mensa Joseph Kwesi, Mensa Tina Gifty Naayele, Mensa Andrew Kofi Ejapa, Morrison Cynthia Mamle, Muntaka Muhammad Mubarak, Musa Abdulaziz Ayaba, Nanja Sanja, Napari Dominic, Nawani Mark Kurt, Newman Dakwa, Nitiwu Dominic Benga Maduna, Inkansabwedu Mavis, Kofi Aku, Ernest Henry, Notuko to Peter Kwesi, in Team Adelaide, in Team Augustine Collins, in Tosu Helen Ajua, Nyakote Albert Tete, Nyako Bismarck Tete,
Present here.
Nyako Kingsley, Nyako Kwame Naminta, Obinte George Pablo, Obim Boateng Alfred, Oklulinda Ohiniwa Kwele, Odamson Isaac Ashai, Ofosu Jari Elizabeth, Okofu Data Williams, Ochri Ejekum Kofi, Opoku Davis Ansa, Opoku Eric, Opoku Isaac Yao, Opon Kuma Kojo, Osei John Frimpong, Osei Kennedy Nyako, Osei Asari Abuna, Ewusu Joseph, Oti John Kwabena Bless, Oti Christian Quality, Owusu Biodo, Owusu Ekufu Esla, Peito Desmond de Graft, Pelpo Abdul Rashid Hassan, Prempe Frida Kosia, Prempe Matthew Opoku, Korte Henry, Quaison James Jechi, Ramadan Muhammad Adamu, Rickis Hagan George Kweku, Safu Sarah Ajua, San Sebastian Mineso, Sani Suleiman Adamu, Sani John Kwabna Abam Abua, Soya Queens Tamami Kokwa, Sefe Richard Kwame, Setre Benjamin Yabua, Osu Francis Xavier Kojo. So Wadela Ajua. So Warita Na Odole. Suparu Adams Mohammed. Sulena Adaman. Sulemana Alasanli. Sulemana Yusuf. Wakao Daniel Sala. Suma Anthony Mbikara. Tahidu Abdul Razak. Tewiston. Tel Aviv Ebenezer Oklite. Tete Joycelyn. Tete Sylvester. Tete Godfrey Gisela. Joseph Akwete. Tofi Dokas. Tobu Peter Lanchini. Tuferi Mohammed Hadi. Chum Ampofu Gifty. Chum Berima Paul Apreku. Yusuf Mustafa. Vandapoy Alfred Oko. Vandapoy Edwin Nilante. Vondi David. Wakao Daniels. Rekubrobe Bright. Woyome Kobna Mensa. Zidin Bid and Watazumo.
I am present here.
Honourable members, now the roll call is over. If you are here and you didn't hear your name, please register. It's the same thing. If you are here, you didn't hear your name, or at the time your name was mentioned, you weren't in, please do the registration. So we move to item 5. Yes.
Mr. Speaker, yesterday we pledged to start work on time. And the media...
Honourable Leader, why wouldn't you allow me to finish item 5?
Because...
which is correction of rules and proceedings, then probably we can look at you.
Because the Speaker is related to what we've just done.
Very well.
Yes.
Okay.
And it must be on record that the reason we didn't start on time today was because Parliament have scheduled to have an interaction with the media. The time that was given to the media, they didn't turn up on time. When we are late to start work, they report it. So, Mr. Speaker, we are demanding that the media report that today Parliament did not sit on time because they delayed Parliament from sitting. So we want to see newspaper headlines saying that Parliament sitting was delayed because we delayed Parliament at the program. It is just fair they do that one as well, Mr. Speaker. So we want to see that.
Well. Let's see what happens tomorrow. We'll be a witness to it. Yes.
Yeah, I think it will be fair on my part to speak in support of what my colleague has said. And I know I see my colleagues, senior media personnel who are hearing us. They should be fair on this occasion. And you have come forth, you have never failed to report late start of business in this House floor. Do say, and let's know that on this occasion, the fault was yours, but not the Parliament of Ghana. So it's very important. And it's also important it goes to the records. I thank you, Speaker.
Well. Yes, Honorable Tenamensa, you still want to speak?
Yeah.
Let me give you the floor.
Mr. Speaker, I don't understand why I'm here, my name, and you are asking that I should go and sign. Please, I want them to record me that I'm here when the name was mentioned.
Honorable member, I'm told you've already been marked. They mentioned your name, you didn't get up, but they saw you, they've marked you. Very well. Yes, Honorable Member for Denta.
Thank you, Mr. Speaker. Mr. Speaker, today I was in the chamber and we tried to establish the mode of response when the roll call is being done. And Mr. Speaker said that ideally people should rise in their positions and then acknowledge. But today I noticed that when roll call was done, there are people whose names were mentioned, but they didn't acknowledge at all. So on what basis were they ticked that they were here because they had not responded appropriately as Mr. Speaker had suggested we do? Thank you, Mr. Speaker.
Well, I think the table could see some of us vividly, so they themselves know the better. Like what my brother is saying. Yesterday, the speaker said, once your name is mentioned, you just rise up from your seat and respond so that the table can see you. So let's do that so that it wouldn't happen that you were here, your name was mentioned, yet people didn't see you. So let's do that. And I repeat, the mere fact you weren't here when your name was mentioned doesn't mean you'll be marked absent. Please do the registration as well. So we turn to item 5. Correction of votes and proceedings and official report. We will begin with correction of votes and proceedings. We start from page 1. Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page number 11. Page 12. Page 13. Page 14. Page 15. And finally page 16. Honourable members, in the absence of any corrections, the votes and proceedings of Tuesday, the 6th February 2024 is hereby adopted as the true records of proceedings. Honourable members, I have in my hands the official report of 21st November 2023. The official report of 21st November 2023. I repeat, the official report of 21st November 2023. Honourable members, in the absence of any correction, the official report of 21st November 2023 is hereby adopted as the true records of proceedings. Yes, leadership, let me come to you.
Speaker, the commencement of public business. May we to page 4 of today's order paper and rather take item 11.
Yes.
We agree to go ahead with it.
Honourable members, let me invite you to page 4. Page 4. Item listed 11. Proper human sexual rights and Ghanaian family values 2021 at the consideration stage. Do you have the chairman of the committee, the vice chairman, the ranking member? Yes, member.
Mr. Speaker, we have the sponsors of the bill around, but we plead with you if Honourable Dakonoko can move those in the name of the committee and the chairman.
Yes. So, return to clause 4. There is a proposed amendment in the name of Honorable Samuel Nati George.
Thank you, Right Honourable Speaker. I rise to move the amendment proposed for clause 4. Delete and insert the following heading: Prohibition against subverting Ghanaian family values. A person shall not, for one, a person shall not directly or indirectly instigate, command, counsel, procure, elicit, solicit, or in other manner purposely aid, facilitate, encourage, or promote, whether by a personal act or presence or otherwise, an act that subverts the Ghanaian family values defined in section 22 of this act. 2. A person who contravenes section 1 commits an offence and is liable on summary conviction to a fine of not less than 750 penalty units and not more than 2,000 penalty units, or a term of imprisonment not less than 2 months and not more than 4 months, or to both. As we move.
Well, honourable members, the proposed amendment on the floor. I guess members are following what is going on in the chamber. Yes.
Thank you, Mr. Speaker. Mr. Speaker, the proposed amendment raises an issue, penalty units. And I think there's a defined table by which a default in paying a penalty unit comes with a defined term of imprisonment. I'm not sure whether what is proposed here corresponds to the table already approved by this House. So I suggest that I wish the Attorney General to guide us whether this corresponds with the table approved by the House already.
Yes, Honorable Member Faswanse.
Well, thank you, Mr. Speaker. I was virtually going to say the same thing. Just to draw attention that the penalty units have their corresponding jail terms. So we don't need to add the imprisonment period. Because once the drafters can pick that, once we state a particular quantum of penalty units, failure of it corresponds to an imprisonment.
Well, on that note,
Mr. Speaker, just so that we revert our minds, when we did clause 6, the issue of corresponding sentencing and penalty units was raised. And the decision of the House was that the drafting units and the Attorney Generals will sit down and harmonize those across the bill. So the substance of what we are doing remains the same, but they will just do those edits by the drafting unit and the Attorney Generals to recognize the penalties and the imprisonment term. So we can take the amendment subject to those regulations by the drafting unit.
yes, Honorable Member Faswanse.
Thank you very much, Mr. Speaker. So that's the reason why at every such clause you need to make reference to this, to say that the drafters have been asked to do the synchronization. But if you don't, when it comes to the interpretation of the law, it means that when you get to this particular, you did not make reference to it, and therefore it's looking like standard law. So wherever we have that, let's just make that reference so that it shows that it is right through the whole bill. Thank you, Mr. Speaker.
So, Honorable Members, do you step down this? The Speaker, hold on. Let me listen to.
Speaker, thank you for the opportunity. Speaker, what we can then do is for the sponsor of the amendment to take out 4(2). Then we leave 4 and carry 2. Then the table office can then, in redrafting the penal section, make provision for 4(2) as it proposed here. So you simply resubmit to the House that the amendment subject to the further amendment. Yes. No, but we cannot approve with 4(2). That's the problem.
You will approve it subject to the amendment, subject to the correction. That's what else it will be going through.
Honorable Members, address the chair, please. Yes. Honorable Minister for Greater Accra Region.
Mr. Speaker, thank you very much. Mr. Speaker, a very good morning to you. And respectfully, may I digress by catching your eye that I'm ably seated on my chair. Mr. Speaker, thank you very much.
Well noticed. Okay. Honorable Member Faswanse.
Thank you, Mr. Speaker. Mr. Speaker, for me, my belief is that the neatest way to do it will be to say that, for example, 2, a person who contravenes subsection 1 commits an offence and is liable on summary fine of not less than 750 penalty units, not more than 2,000 penalty units, term of imprisonment corresponding to the penalty unit. With that, you block it and you allow the drafters to deal with it. Yes.
Mr. Speaker, if to avoid any confusion and going back and forth, I've just been given the table, the corresponding table, so I can move a consequential amendment here to do the corrections to align with it so that we proceed. If it's either we leave it to the drafters to do it across bill or we do it here as and when we go. So we are in your hands, Mr. Speaker.
Mr. Speaker, I suggest that a substantive amendment has been taken. You can direct the legal directorate to effect the appropriate insertions with regard to
the imprisonment corresponding to the penalty. Thank you.
Yes.
My little experience have shown me that sometimes when you refer to drafting the legal directory and so on, the final document that comes out does not reflect really what we intended. So I think that whatever they do, they should bring it back here so we see it. There are cases where the thing has been signed, even have gone as far as the presidency, and then this is not the exact reflection of what we did. With the greatest respect to the drafting side, the legal, or whatever they do should come back here so we can see it.
Well. Honorable Leader, you wanted to speak. Eh?
Mr. Speaker, with respect, I was going to suggest to my respected colleague to proceed to do the consequential motion, and so that we deal with it once and for all. I mean, the same sentiment that was expressed by Honorable Jogati. So if you can go ahead so that there will be clarity, certainty, and thank you.
So the direction is that we should allow him to move all his amendments, but when it comes to the areas of penalty, we should hold on till we get Attorney General's direction or the draft give us.
If I hear what he's saying, since we have the table here, and we know what the table tells us what 750 penalty units is, and tells us also what 2,000 penalty units is, I will just make, in fact, it is just a consequential amendment, and then I retable the amendment and we carry it, so that there is harmony. So, Mr. Speaker,
okay.
4.2 will read, a person who contravenes subsection 1 commits an offense and is liable on summary conviction to a fine of not less than 750 penalty units, more than 2,000 penalty units, or a term of imprisonment not less than 2 years and not more than 4 years, or to both, because that is the corresponding with the penalty units. I so move, Mr. Speaker.
Well. Yes, Honorable Member for Aswanse.
Thank you, Mr. Speaker. So now the problem now is, if you look at the intent, our hope was that the imprisonment term will not be more than 2 months and 4 months. So we should rather pick its corresponding penalty unit. Other than that, what you simply be doing is that using penalty units that will be imposing higher prison terms more than what you intended. Since your intention is for 2 months and 4 months, rather pick a corresponding penalty unit for that instead of the 750 and what do you call it, 2,000. Because I want to believe that our intent is not to give steeper prison sentence, but it's a deterrent. So the 2 months and 4 months, we should rather look for its corresponding penalty unit. Thank you, Mr. Speaker.
Very well. So on that note, Honorable Nati, will you?
So again, the intent is not long custodial sentences. So I agree and associate myself with the point made by the respected member from Asawasi, Honorable Muntaka. And so we would rather propose now that it will read a fine of not less than 50 penalty units and not more than 100 penalty units, or a term of imprisonment of not less than 3 months and not less than 6 months, so that it keeps it within the intended time frames that we wanted. 3 months, 6 months, 50 penalty units, 100 penalty units.
Yes, Honorable Leader.
But his original proposal was not less than 2 months and not more than 4 months. What you are telling us now is completely different from what you had intended. If you want to follow the suggestion that there should be a corresponding penalty unit, then I don't see how suddenly you want to change what you propose. Because, yes, I agree, but what I'm saying is that the motion on record is to the effect that we are looking at penalty unit or term of imprisonment not less than 2 months and no more than 4 months. Are we saying that there is no penalty unit to correspond with the 2 months imprisonment? There's none. Then if there is none, then it shouldn't increase, because Mr. Speaker, the thinking of our courts now is not to put people in jail. So what I'm saying is that why don't you rather reduce it? To say that there's no specific penalty unit for 2 months, we should rather increase it to 3 months. Just clarify for me, please.
Yes.
Speaker, just to give clarity, you see, and let's be clear, originally in the bill, the proposed amendment was for 750 penalty units, which is equivalent to 9,000 Ghana cedis, or a period of imprisonment of 2 years per our guideline. And then not more than 2,000 penalty units, which is equivalent to 24,000 Ghana cedis, and a term of imprisonment of 4 years. But because the intent is not to have long custodial sentences, we've decided to drop the term. And if you look at the guideline, you have 30 days, 3 months, 6 months, 12 months. And that's why we've gone to between 3 months and 6 months. But you should bear in mind that in doing that, we've been forced to also drop the penalty units to 50 and 100. Just so that we are clear, 50 penalty units comes to only 600 Ghana cedis. Only 600 Ghana cedis. And then 100 penalty units comes to just 1,200 Ghana cedis. So in trying to check, I hope the respected member for Efutu is paying attention. Mr. Speaker, in trying for us to reduce the sentence duration, we are also, but we give the option of fines. You drop the fines to literally 600 Ghana cedis or 1,000.
The commensurate, if the commensurate penalty unit cannot be defined within the context of the proposal, which is 2 months and 4 months, then we should not go higher. We cannot therefore say that the nearest is 3 and 6. We can also have the nearest being 1 and 3. So, Mr. Speaker, we should rather look at 1 month and 3 months instead. I thank you.
I think we shouldn't litigate this. We are passing a legislation that ought to act as a deterrent. And if you are acting as a deterrent, let us be mindful. Then we can as well say that we are not even going to pass this legislation. Because if you are going to pass a legislation and it's a punishment where the judge can fine the person 300 Ghana cedis, then we are making a mockery of this whole thing. So for me, even the 600 cedis is a bargain, simply because you are just trying to make sure that you don't have extensive custodial sentencing. But the judge has the discretion imposing a fine or an imprisonment or both. And so for me, at 600 Ghana cedis and 1,200 Ghana cedis, 3 months minimum, 6 months maximum is at least good deterrent enough. Mr. Speaker, I think that the debate and put a question. If anybody is opposed to 3 months, 6 months, 600,000 to, they can vote, and those in favor will vote, and we proceed. Thank you, Mr. Speaker.
Yes, Honorable Members.
Thank you, Mr. Speaker. Mr. Speaker, it's really a very difficult situation because, Mr. Speaker, frankly speaking, the penalty unit is small. Because 600 Ghana cedis is not deterrent enough. It's just too often that it is tied to the imprisonment of only, 3 months. Mr. Speaker, I wanted to find out whether, as a house, we would maybe do only a fine and leave the prison term, because all of us don't really want to pack our prisons with too many inmates. But so that we can keep the 750 penalty unit and 2,000 penalty unit, which is harsh, but without an imprisonment term. It's an option for us. Maybe the only difficulty then is that in the court, if the person says that I don't have money, what happens? I don't know. I was thinking that if we keep the penalty unit high, which is punitive enough, because if you look at 750 and 2,000, that's punitive, so we take away the prison terms. So it's only a fine. The difficulty is that if you are in court and you say, I don't have money, well, what happens? Immediately the judge will look for the corresponding imprisonment terms, which is also too high for us. So in this case, I don't know how we are going to be able to tackle it. Maybe the easiest is to keep to what Honorable Samdon is saying. Let's keep to the 50 penalty unit and 100 penalty unit, and then the 3 months and 6 months, and put the question on it. Thank you, Mr. Speaker.
Well, I don't know whether the Attorney General can advise.
Right, Honorable Speaker.
Yeah, the way.
Speaker, I think that we, as sponsors, we are debating it. The particular clause is on subverting Ghanaian family values, and we may be aligned to dropping the custodial sentence, but raising penalty point to units to a very deterrent rate, such that we could do minimum of 2,000 penalty units, which is equivalent to 20%, and not exceeding 3,500 penalty units, which is equivalent to 42 Ghana cedis. If we do that and take out the custodial, so that is deterrent enough.
I wish we have an Attorney General or he's here to advise us on that, whether we can just limit ourselves to the leader. You want to? Yes.
Mr. Speaker, I'm too sure that you can have any proper sanction regime without the commensurate incarceration period. You cannot. What if the person says that he doesn't have the money? What happens? The person is free. I can't see, unless maybe we can have some construct. For instance, that okay, if you cannot do it, then maybe we'll have to submit to, let's say, some community service. Some community service. Otherwise, you cannot have any sanctioning regime without absolute term of imprisonment. That's number one. The second one that I've observed, just listening to the 4-1. The 4-1. The person shall not directly or indirectly instigate, command, counsel, procure, elicit, solicit, or in any other manner purposely aid. Why do you raise the bar by the insertion of the word purposely? How do you determine the intent of the person? So I can't. Why have you introduced that? Because it raises the bar. When you say that the person, the intent of the person should be determined, whether he did so on purpose or not. Why do you introduce that? This is for your group. The purpose. You are raising the bar. The determination of the purpose then comes into the matter. The commission has happened. For the office. Now you want to determine whether it was done on purpose or not. That's another matter. So, those are the two issues that I wanted to raise.
Yes. Honorable, before you come in, Mr. Speaker, is it necessary, always the case, that the penalty should correspond with the sentencing regime? Yes, I think we can craft the legislation in such a way that we can limit the sentencing regime but raise the bar of the penalty units.
Unfortunately, as has been suggested, once you sentence the person to a fine, if the person does not pay the fine, there must be a corresponding
But I'm going to suggest, and this is your amendment, so I'm suggesting it to you, Honourable Member for the Trump. Do we necessarily want an offender to pay a fine? If not, we can just say 6 months imprisonment without an option of a fine, or 2 months minimum, 6 months without the option of a fine. In that case, there's no choice. As long as we introduce a fine, then a failure will correspond to someone. But the amount proposed in the fine, in my view, is ridiculous. On summary conviction to a term of imprisonment not less than 2 months and not more than 6 months. There's no option of a fine.
Honorable, that's the further proposed amendment.
Mr. Speaker, I'm amenable to the further amendment.
Yes.
We're taking out the penalty unit, so it's just no fine.
Yeah.
It's just 2 months minimum, 6 months maximum. We are amenable.
Yes.
Speaker, I believe the matter is settled, so the amendment can be carried. But the fact is that there are penal provisions in other laws where when a person is convicted, the option for the court is only a fine. A lot of in my practice, I've come across it. What happens is that when you are unable to pay the fine, you remain in the custody of the court until, especially offences regarding in the ECG Act, power theft, and I think there's Senate non-payment of Senate pension, so Senate deductions. There are provisions like that where the court is only open to fine you, and if you are unable to fine, you remain in custody for a couple of days. When you find pay, and then you walk free without an option of imprisonment. So this House has enacted provisions like that.
You are going with what?
Yes. So I am going with Speaker.
Very well.
The matter is settled.
So, honourable members, the matter appears to be settled now, and the question is: those in favour of the
It's the issue that I raised with the word purposely. I don't know what you think about that. In one, purposely. I'm not too sure that. Yes.
Mr. Speaker, we are not going to litigate the use of the word purposely, so also delete it. So it will read, a person shall not directly or indirectly, and I hope the honourable member for Swami is paying. I want to do the new rendition. Should we keep the purposely or take it out? I think the purposely should be there.
Yes.
Mr. Speaker, well, yes, I may agree that they may want to think with some other clause, but this clause that we've agreed should be put and then settled before you can go to another. Another will be mixing. No, the amendment we are currently doing is 4.2. So put the question on 4.2. Then you go back to 4.1 if there's issue, because at consideration stage is flexible. When you mix them, then we don't know what we are even voting for.
So, honourable members, the question to 4.2, that is the further proposed amendment.
So, Mr. Speaker, is it the case that the 4.2, there will be no fine? Mr. Speaker, what is the thinking of our court? We have a new sentencing policy by the judiciary. Let's be very clear, and this is a law. Not attach emotions where there's disagreement. We want to do a gallery debate so that there will be like, who are those against and all that. Mr. Speaker, the court has a position sentencing. Mr. Speaker, in fact, it's the reason why we now have introduced this plea bargain thing. The plea bargaining law that we have enacted is also aimed at dealing with some of these things, where even serious criminal matter person, is repaid to deal with the issue of the time for the trial and all, and also depopulate our prisons. The cost to the state, and even when people go to prison, they become worse off, and a lot of studies on that. So this parliament must not depart from that. So please, colleagues, we can go away with a fine. And we should not attempt to say that merely being guilty of this should lead to imprisonment without an option for a fine. Let's be careful what we are doing, respectfully.
Yes.
Speaker, I see the wisdom in the point being made by the Deputy Majority Leader. But the sentencing policy is only a guide for the court. The court still has the power to convict pursuant to legislation. And the sense of the House today is to legislation in such a way that when you are guilty of this particular provision, the court's hands are tied. We can do that. We can, in the course of the other provisions, make for a fine for custodial sentences or to both. But we are saying that in this particular case, we are tying the court's hands. And this House has the power to do that. It is not to depart from the sentencing policy presently in place. It still does not override the tenor of the law. So where the trial is such that the evidence is such that your hands are tied, your hands are tied.
Leader, must it always be the case that the sentencing or the fine correspond to the sentencing regime? Can't we as a House also tell her that we raise the fine to correspond to, not necessarily to correspond to the standard sentencing regime? Is it not possible for the House to do?
Speaker, before I come to your question, let me address my colleague Defiamapo on the point earlier raised by me, which he had his right to respond. So, Speaker, the law is that when a person is guilty, he must suffer consequences. And studies have shown that when suffer consequence of their actions within the remit of the law, and that consequence amount to imprisonment, they become worse off. This is a known fact. We've had several discourse on this matter, and is the reason why our courts have now shifted from that strict custodial sentencing regime to giving an option of a fine. I need to reiterate the point earlier made that even in causing financial loss to the state, even in situations that the state has lost money, where the previous position of the law was that, well, you go to jail. Now there is a new regime that allows for you to pay back to the state and avoid the prison sentence. Mr. Speaker, previously we had something called non-bailable offenses in our courts. Non-bailable offenses, where upon being charged with a particular offense, the hands of a judge and the hands of a lawyer, the advocate, is tied. We've moved away from that. Mr. Speaker, again, our criminal jurisprudence has also introduced a new system where all cards are table. Previously, the prosecution will carry his evidence under his armpit hidden and be dropping it one after the other. Now they say disclosure. Give every ab initio. And that is the law. This parliament can mean to be departing from this new regime. We cannot. It is our bona fide to pass laws, and I agree with you on that. But I disagree if the suggestion is to the effect that because we enjoy this bona fide, we should proceed to enact and deny people the option of reform. Mr. Speaker, now I'm going to the second leg of my argument. Sentencing should be aimed at reforming. We are saying that a person who, for some conduct, is acting contrary to our value system in terms of sexuality and all that should suffer some consequence. That's fine. But should the person be worse off because of orientation? Should the person go into incarceration and will not have an opportunity to be a good citizen on a mere misdemeanor? Mr. Speaker, I beg to disagree. I beg to disagree. And this disagreement is not founded on any stampeding. It is founded on funds well known in our courts. May my honorable colleague,
I'll give you the opportunity. Let me finish. Once you finish,
patiently wait for me to finish.
No, I'll give her the opportunity. Let her.
So, Mr. Speaker, let this matter rest. Let this matter rest. We allow a way for reform. And that can only be achieved, Mr. Speaker, if we legislate and give way, allow the judge the opportunity to give the person the fine. If we say no fine, Mr. Speaker, we wouldn't be doing justice to the matter. I thank you. I pray that they appreciate.
But I hope you were going to address my question.
Mr. Speaker, the lacuna will find ourselves. The lacuna will find ourselves. We can maintain the initial proposal, the 2 months and the 4 months. It wouldn't be illegal. It wouldn't be unlawful. Because that provision is not a constitutional provision. That provision you refer to is not a constitutional provision. Therefore, if it took the opportunity to the judge, for the judge to impose a penalty, which penalty would mean X amount. However, if you're unable to pay, go in for 2 months. Mr. Speaker, I don't think that it would be wrong for that to be done. The fact that the commensurate unit does not mean that a judge cannot sentence somebody for 2 months. Judges sentence for even an hour. Sentence where there is no such legislation, they are able to say that I'm sentencing you in the case of contempt. A judge can sentence you for 24 hours. He can sentence you for 24 hours. But there's no commensurate penalty unit for a 24-hour incarceration. Mr. Speaker, I will make the point clear.
Yes.
Thank you, Mr. Speaker. Mr. Speaker, if we go by Deputy Majority Leader's interjections, it looks like we won't go forward at all. He's made his point. We've heard him. We've also made our point. So, Mr. Speaker, put the question. Thank you.
Mr. Speaker, Mr. Speaker, let me finish with this. We are legislating, and the practice has always been that we brainstorm. I therefore disagree with the phrase interjection, that with its interjection. Is it the case that we shouldn't express our views? Then you carry it as sponsors and say anything you want to say. So please withdraw the interjection. I'm expressing a view based on your own amendment. All right? So please, I don't want that to be in the records. I'm not interjecting you.
So you are suggesting. Thank you.
Yes, Honorable Member for Swansea.
Thank you, Mr. Speaker. I was one of those who raised the initial concern about the corresponding penalty unit and prison terms. But from the Deputy Leader, who is also a lawyer, I want to believe he's been practicing in the court, and it's making me believe that it's not all the cases that the penalty unit must correspond to the DSM. If that is the case, then the Speaker has to keep the original rendition of the, what do you call it, a fine of not less than 750 penalty unit and not more than 2,000 units, or a term of imprisonment of not less than 2 months and not more than 4 months or both. So let's keep the original and put the question to
Very well.
Thank you, Mr. Speaker.
Well.
Mr. Speaker, if the purpose, if the intent of this House is what I hear Honorable Muntaka say, as the mover of the motion, I'm not opposed to it. That let's give a high penalty, you know what I'm saying? Because you see, Honorable Afenyo's argument is different from what Honorable Muntaka is saying. He is saying that we should maintain 2 and 4 months and use commensurate 2 month, 4 month fines. That's what he's saying. And I'm saying that if what Honorable Muntaka is saying is let's maintain it as it was, 700 and penalty units and not more than 2,000 penalty units. And when it comes to incarceration, not less than 2 months, not more than 4 months. They don't need to correspond. And let's continue that way.
Mr. Speaker, the logic is right. However, the penalty unit should not make the person worse off. The penalty unit should not make the person worse off. The logic is right. That is, you don't necessarily need to have a commensurate penalty unit here. However, if you are going to keep 750, then that is really on the high side. So let's maintain the no less than 2 months, no more than 4 months. However, get a lesser penalty unit, which, because if you maintain 750, what 150? Because you also don't want to unduly overburden the person. You want the person to reform. That is the motive. That somebody who has acted this way, you don't want the person to repeat it, but at the same time you want the person to reform. So you can maintain the 750 penalty units, respectfully.
Honourable members, I think what we debated on this particular issues, once we are not at fault, correspond the sentencing fine, then I think the House can give the fine not necessarily corresponding to the sentencing, and I'm advised by the drafting department that it can be done. So I think if you can give us a new rendition with respect to your amendment, then if somebody is against it, we'll put it to a vote, then we move on.
Mr. Speaker, the rendition will remain as it is proposed on the order paper. A person shall not directly or indirectly instigate, command, handle, procure, elicit, solicit, any other manner, purposely aid, facilitate, encourage, or promote, whether by a personal act or presence or otherwise, an act that subverts Ghanaian family values defined in Section 22 of this Act. 2. A person who contravenes subsection 1 commits an offence and is liable on summary conviction to a fine of not less than 750 penalty units and not more than 2,000 penalty units, or a term of imprisonment not less than 2 months and not more than 4 months, or to both. I so move.
Very well. Honourable members, I'll put the question. All those in favour of the proposed amendment say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment is. We turn to clause 6.
Honourable Speaker, clause 6, amendment proposed. Subclause 2, delete and insert the following. A person commits an offence under paragraph A, B, C, D, E, F, or G of subsection 1, a misdemeanor, and is liable on summary conviction to a fine of not less than 750 penalty units and not more than 5,000 penalty units, or a term of imprisonment of not less than 2 months and not more than 3 years, or to both. I so move. Mr. Speaker, the rationale for this is the rationale for this is that this really the clause that deals with the offences of this bill, the offences of homosexuality in all of its shapes and form, whether it is lesbian, gay, transgender, pansexual, pansexual, ally. And that is why we are imposing what appears to be the harshest sentence in the bill. And so for that we are proposing 750 penalty units minimum, maximum 5,000 penalty units, or a term of imprisonment of not less than 2 months, even if you were caught sacked, but maximum sentence of 3 years in the Act. Thank you, Mr. Speaker.
Honourable members, there is a proposed amendment for the House. Yes, Honourable Leader.
Mr. Speaker, let me get some clarity from the sponsor. Does that mean that the judge would have a discretion as to whether to impose a custodial sentence or a fine? So it cannot be that in default of a fine, we cannot give the judge the option of imposing a fine? Yes, because you see, Mr. Speaker, we have to ensure clarity. And I will also go early argument of the decongestion of our prisons and the sentence regime we have. Therefore, I would want to propose that we further amend line 5. Mr. Speaker, line 5. Or we insert in default. Before or we insert in default. Not, Mr. Speaker, sorry. After all, we insert in default. The new rendition would read: a person who commits an offence under paragraph A, B, C, D, E, F, G, E, F, or G, or subsection 1 commits a misdemeanor and is liable to summary conviction to a fine of not less than 750 penalty units, or in default. So, Mr. Speaker, a term of imprisonment of not less than 2 months, and no more than 3 years, or to both. Mr. Speaker, I think that or to both must go. Or to both must go. Or to both must go. Yes, because
Right, Honourable Speaker, as the sponsor of this amendment, I'm opposed to amendment, and for good reason. The intent of this is to allow the judge the discretion to either give a fine, a custodial sentence, or choose to give both. Further amendment that is being moved is tying the hand of the judge to only a fine, and then if the person defaults in the fine before he can go into a custodial sentence. That is not the intent of this bill. The intent of this is to say that the judge can choose to fine you and let you walk. He can choose to incarcerate you and let you walk, or he can choose to do both. Let's leave that discretion to the judge. Let's not tie the hands of the judge.
Sam,
thank you.
That is fine, but that is his first proposed amendment. That is the view that he wants the sanctions to be. So you have your position. It's right. His position is also right. That's what he believes in. Very well. Yes.
Speaker, I support the position of some judge in the matter, in the sense that there's a lower limit to the penalty you apply when you are guilty and convicted, and there's an upper limit. Then the judge has the option to also impose a custodial sentence by abandoning the imposition of a penalty. Or the judge has the discretion to impose both a fine and a custodial sentence. So this is a standard drafting style that we take. If my brother is saying that we shouldn't combine, give the judge opportunity to the discretion to impose a fine and a custodial, then he can say so expressly and engage the mood of the hour whether we can adopt that. But I think that this is a standard provision. The judge will have that discretion to impose a fine, to impose a custodial sentence, or to both. So I support the sponsor of the amendment.
Very well. Yes. Leader.
Mr. Speaker, first of all, we have defined this offense to be a misdemeanor. In a misdemeanor, we are saying that we give a judge the option to impose a fine and at the same time a custodial sentence. Meanwhile, in some serious offenses, causing financial loss to the state is not a misdemeanor. Yet, in that, we have now enacted a law to allow the person what we call plea bargain, where there is no such straight line as to the person, if the person is guilty, go to prison, as it was previously. Mr. Speaker, again and again and again, let's be careful as a house. We've defined it as an offense, a crime. Yes. We've again said that it's a misdemeanor. If it is so, then the appropriate thing to do, and I call on my colleagues, our officers of the court, to aid this house on this occasion, that if it's a misdemeanor and properly defined misdemeanor, then the person should have the first option given by the judge by way of that penalty, that if he defaults, in that case you can now talk about custodial sentence. But Mr. Speaker, enacting this law this way will not be in accord with our own laws that we've enacted in this chamber. So let's be careful to say that we should impose a fine and custodial sentence at the same time. I hold the view that is the enactment. That is what you are enacting. That is exactly what you do. And my colleague, Dafiamepo, got it right Because if you say or both, what are we saying? Let us put in default. If the person defaults, the judge can now impose the custodial sentence. But you can't say that, a judge, what if the judge, per his orientation or her orientation, is so prejudiced that he or she would want to, go for a kill. What happens? Mr. Speaker, once again, I'm reminding all of us that we are legislating on a matter that deals with of citizens and individuals. So let's be minded in the approach. Let us put in there in default. If the person default, the judge can now move on to say that you've defaulted. You can now go to jail. You cannot say you should do both. No. One must give way to the other. You cannot.
Very well.
Speaker, I am suggesting that let's put the fine there. Then in default, we can talk about the custodial sentence. That is in accord with the sentencing regime, the sentencing policy of our court. Unless we want to depart, then we may want to do what we want to do.
Yes, Honorable
Speaker, again, my brother is invited us as officers of the court to assist the House. So we will. He's making passionate arguments. And we are saying that we are leaving discretion in the hands of the judge. Why? Because there will be circumstances where there will be repeat offenders. Yes. Now, in the scenario that he paints, if somebody is a repeat offender, he will be given the option, the judge's hands is tied. So we'll be given the option to keep imposing a fine. And the person who keep paying the fine will go and come back. But in the event that we leave the provision the way it is, and the judge exercises the discretion in favor of the accused person or of the convict, by imposing a fine as the sentencing, not a custodial one, he finds the money, he pays, he walks. It is known to the court. So if it comes back as a known offender, then the judge will now exercise the discretion in such a way that he will be imposing either a higher ceiling of the fine as well as a custodial sentence. So I see the wisdom in his argument, but he should take into consideration situations where we will have repeat offenders, where the judges will now have to operate within the confines of the law and exercise their discretion. So I urge you to disengage and take the amendment. Thank you very much.
Yes, Speaker.
Speaker, I believe that this is a feature of most of the laws that we're making. And it is really the purpose of serial offenders. A one-time offender may not really attract us. I serve the purpose of serial offenders. So I would urge my colleague to be minded of that and move on. No.
Very well. So I'll put the question on 6.2. All those in favor of the proposed amendment to clause 6.2, say aye. All those against, say no. Honourable members, the ayes have it. The proposed amendment to clause 6.2 is carried. So we turn to clause 6.3. There is a proposed amendment by the chairman of the committee. Chairman of the committee.
Speaker.
Very well.
Yes, Speaker, thank you for the opportunity. Speaker, item number 3, clause 6, amendment proposed, sub clause 3, delete and insert the following. For the avoidance of doubt or natural carnal knowledge referred to in subsection 2 of section 104 includes A. Sexual intercourse between and among persons of the same sex. B. Sexual intercourse between a man and an animal or an animal. Or C. Sexual intercourse between a man and an inanimate object, or a woman and an inanimate object. Chairman, I so moved. Thank you.
Honorable members, clause 6.3, there's a proposed amendment by the chairman, which has been done by the member of the committee. Clause 6.3. Leader, do you want to?
The Speaker, 6.3 in this amendment, it says, for the avoidance of doubt, unnatural carnal knowledge referred to in subsection 2 of section 104 includes, what are we talking about? Subsection 2 of section 104. Where's the section 104?
Speaker, I agree that we should get section 104 of Act 29, 1960. It should have formed part of the body of the proposed amendment. It's an omission. Yeah. So, Mr. Speaker, may I further amend the present amendment by saying that for the avoidance of doubt or natural carnal knowledge referred to in subsection 2 of section 104 of Act 29, 1960 includes then all the A, B, C as humbly submitted. Thank you very much.
Mr. Speaker, this amendment is by the chairman of the committee, and if you look in at the committee, as sponsors were opposed to this amendment, and if you look at the further amendments to this clause, as proposed by the Honourable Chairman Sambonso and myself, we would rather oppose this and wish that this amendment is defeated, and then we consider the other amendments to the original rendition in the bill.
Why? So you oppose it, then you can propose your own counter amendment or whatever it is.
So Mr. Speaker, our counter is on the other paper, and so the reason why as sponsors we are opposed to this is that this one has simply gone to pick another carnal knowledge from section 104 of 29. But if you look at the way we have defined it in the bill, the original, the proposed rendition in the bill, if you insert the amendments that have been proposed, further have been proposed by Honourable Chairman Samboso in 4, 5, and what I have proposed in 6, it gives full essence to what the chairman is proposing and even more. So that is a more comprehensive, because if the current rendition in the bill, it says for the purposes of this section, sexual intercourse occurs where a person penetrates the anus or mouth of another person with the penis of that person or other contraptions, or B, a person by use of any object or contraption penetrates or stimulates the vagina or anus of another person, or C, a person by use of the person or any other object or contraption penetrates the anus or other bodily openings of an animal for sexual gratification. We believe that further amendments to this would capture section 29, section 29 and 4 of Act 29. If we attach the amendments in 4, 5, and 6. So our position is that you put a question, we want to defeat the chairman's amendment and carry the other subsequent amendments to it. And Mr. Speaker, let me reassure Honourable Member for the Odio, Honourable Nilante Vanderpoel, that his fears are not are catered for in this bill, because the Honorable Nilante Vanapoy is worried about when they talk about certain kinds of actions, but that's why this talks about sexual intercourse as is used in this bill. And sexual intercourse in this bill refers to sex between a man and a man, a woman and a woman, a man and an animal, or a woman and an animal. So what Honorable Nilante is worried about, if it happens between a man and a woman, is not the intent of this bill and the concern of this bill. Thank you.
Yes. Honorable Sam George, I intend to step down the chairman's amendment. Our Afwesh is here to give us the intent of fine, it's committee now, it's before the house, and we all have to be informed. So we want us to vote on it and probably shoot it down. I will rather advise that let's step it down for the chairman himself to be here and probably give us the intention or the reason behind this. That is my proposal anyway. Yes, leader.
Mr. Speaker, first, the section 6 is on sexual intercourse. What is being proposed here? The deletion of 3. It is not to follow after 3. If the proposal from the committee is that let this follow after all the amendments in 3, that would be something. But he's saying that we should delete 3, and that's where the problem is. That's where the problem is. So I would maybe, if we have to move on, I will want to associate myself with what you said. Let's stand it down. But if it has to be brought back, it cannot be the deletion of 3. It will come after all the 3, maybe adding to what obtains in the Criminal Offences Act. So that is it. So we can stand it down and then move on and then consider the amendments.
Well.
Speaker, I agree with leader because the amendment in the nature that it is, it necessarily has to be dealt with. Otherwise, if we stand it down, then we cannot handle items number IVVVI. They are consequent on that provision. So, as a member of the committee, I believe I have the power to move the amendment subject to the consideration of the House. So I may have to withdraw the amendment and allow the House to proceed with the existing provision in the manner that it bill, so that the amendment being proposed in IVV and VII can be carried or can be considered and dealt with. Then perhaps when Chairman appears tomorrow, his proposed amendment would have been overtaken by events. And it may not be necessary for him to move it.
Very well. Honourable members, in the event that if I is stepped down, we cannot proceed with the rest. That is his position. Did I get you right?
No, Speaker. I'm withdrawing the amendment I move on behalf of the committee, so that the House will be seized with the existing provision in the bill, and such that the proposed amendments consequent upon those provisions can be dealt with by the House.
Okay.
Yes. Thank you.
Okay. So, honourable members, we will hold on with I and move on to IV. So, there is. I think so. So you've withdrawn.
Is withdrawn. Is withdrawn.
Very well. So let's move to IV of clause 6. That is sub clause 3. There's a proposed amendment by our leader, Honorable H.M.S. Leader, we have the floor.
Speaker, it's just a simple insertion. After illness, we have, for purposes of this section, sexual intercourse occurs where a person, by use of the penis of the person or any other object or contraption, penetrates the anus or other bodily happening of an animal. The Speaker, through, we've been mentioning the vagina, and I was thinking that we just need to insert those words. I just noticed that we also have mouth. So maybe we may include that. Mouth, anus, mouth, or other bodily opening of an animal. I think that is how it should be for C. Yes, after anus, mouth, and set.
So, leader, can you give us the rendition so that we can?
So it will read, a person by use of the penis of the person or any other object or contraption penetrates the anus, mouth, vagina, or other bodily opening of the animal.
Thank you very much. Honorable members, there is proposed amendment by the leader, and the question is, all in favor of the proposed amendment, say aye. All those against, say no. Honorable members, the ayes have it. The proposed amendment is carried. To clause 6, 3D.
Yes, Mr. Speaker, it is proposed to have a new D. You realize that for 3A, B, C, we're talking about penetration. That means usage of the male organ. What of the female organ is not here indicated. And so we should find space for it. I don't know whether it should read a woman has sex with an animal or a person allows penetration by an animal. I don't know how to capture that. But the simple message is penetration of a person, a female, by an animal.
Very well. Yes, Sam.
Subsequent to the explanation, I think we could couch it, a person allows penetration of the vagina, anus, or mouth, or any other bodily opening by an animal. I don't know if that deals with it, so penetration by an animal. So I'll take that again. A person allows penetration of the anus, mouth, vagina, or other bodily opening by an animal. Of that person by an animal. That would be how it's read.
Very well. Honourable members, this is the proposed amendment, and the rendition has been read to us. All those in favor of the proposed amendment say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment to 6CD, 63D is carried. We move to 6.4 by St. George.
Right, Honourable Speaker, I'm also proposing that we add a new subclause 4, which will take care of what was proposed by the chairman earlier. This section shall be read together with section 104 of the Criminal Offences Act 1960, Act 29.
Yes, there's a proposed amendment adding clause 4 to the existing one. Yes, leader.
Mr. Speaker, I don't know whether, in particular, we may have to specify by inserting subsection 2. That then would cure what proposal that was coming from the chairman. Because it's
Honorable Sam George, are you listening?
I was saying that we can further amend this to sync the intendment of the chairman's own amendment by inserting subsection 2, so that this section shall be read together with subsection 2 of section 104 of the Criminal Offences Act 1960. Because that is what the chairman sought to do. But once we achieve that, the chairman's own can then fall. Yes.
Very well. So, Sam, can you then reframe it for us?
Mr. Speaker, it will read add the following new sub-clauses 4. Subsection 2 shall be read together with section 104 of the Criminal Offences Act 1960, Act 29 in brackets.
Leader, this we just read this section. We're talking about the entire section of 6.
Leader, then kindly help us reframe it for us.
This section, that is the 6 that we are dealing with, we read together with subsection 2 of section 104 of the Criminal Offences Act 1960.
Very well. Honorable members, all those in favor of the proposed amendment say aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. So let me put clause 6 as variously amended. So honorable members, all those in favor that clause 6 as variously amended, say aye.
Speaker, I believe inadvertently we left some leg. A standing part of the bill. We left that one out. Maybe we can just take it back.
So, honorable members, clause as variously amended with regards to the outstanding aspect that needs to be corrected. Yeah, to be part of the bill. All those in favor say aye. All those against say no. Yes, the ayes have it. The proposed amendment as variously carried, noting that there's certain aspect that to be carried as it is carried. So we move to 8. Clause 8. We move to clause 8.
Yes. Yes.
Yes.
Speaker, thank you. Item number VII, clause 8. Amendment proposed, lines 2 and 3. Delete an offense and insert a misdemeanor. And in line 4, delete of less than 1 year and not more than 5 years, and insert not more than 3 years. Ably moved. Thank you.
Yes, honorable members, proposed amendment before the House. That is clause 8.
Speaker, by way of defense is to reduce the sentencing regime and also define the offense division. It's just to bring clarity. Thank you.
Very well. So all those in favor of the proposed amendment of clause 8, say aye. All those against, say no. Honourable members, the ayes have it. The proposed amendment is carried, and that clause 8 stands part of the bill. We turn to clause 9. Clause 9. But it's just one. So clause 9.
Speaker, thank you. Item number VI, amendment proposed. Delete and insert the following. A person commits a misdemeanor if the person A keeps or manages or assists in the management of a brothel for the purposes of a sexual activity prohibited under this act. B, being a tenant, lessee or occupier or person in charge of premises knowingly permits the premises or part of the premises to be used as a brothel for the purposes of a sexual activity prohibited under this act. Or C, being the lessor or landlord of any premises, or the lessor or landlord, I, less the premises or part of the premises, with the knowledge that the premises or that part of the premises is to be used as brothel for the purposes of a sexual activity prohibited under this act. Or 2, is woefully a party to the continued use of premises or a part of the premises as a brothel for the purposes of a sexual activity prohibited under this act. So moved, Mr. Speaker.
Very well. Honourable members, the proposed amendment is before us. That's clause 9. Yes, leader.
Mr. Speaker, earlier on, we have dealt with movable assets. We have dealt with movable assets. Now, this one being proposed by the chair does not include what we had already dealt with. And which is why, Speaker, rendition. And I think that what I've done might be sits better than what the committee is proposing via the chairman. So if you can look at what has been done for same line in Roman number 9 and captures it. No.
Mr. Speaker, once again, we will urge the Honourable Roxon, who is standing in for the chairman, to abandon his amendment so that we can consider the further amendments to this same clause as proposed by the leader of the House, because we think that those capture the essence of what the intent of the sponsors is. So, if Honourable Roxon is so guided, he can withdraw this and then we look at the other amendments. Thank you.
Yes, Honourable Roxon, will you abandon the proposed amendment?
I can only withdraw it.
Okay.
So let me withdraw the amendment as proposed, standing in the name of the committee chairman.
Very well. So if the amendment is withdrawn, then we will move to clause 9. proposed amendment by the leader. So, leader, you may put across your amendment.
In view of what we did earlier on, that we delete clause 9, and in its place we have this. One, a person who keeps a movable asset, a room, a house, or any other asset for purposes of a sexual activity prohibited under this act commits, Speaker, here I have second-degree felony. That is from what obtained. Now that you have agreed that its brother should be misdemeanor, again we can delete that and insert that. You commit a misdemeanor and is liable or summary conviction to a term of imprisonment of not less than 3 years and not more than 6 years. Again, we can look at the sanction regime. Sanction regime again. The Speaker, a person who being the owner or occupier of a moved asset, a room, a house, or any other asset, or having or acting or assisting in the management or control of the premises, induces or only allows the person to be in or on the movable asset, room, house, or any other asset for purposes engaging in or promoting a sexual activity prohibited under this act commits, and we can, as I said, align with the offense, and is liable or summary conviction to a term of imprisonment not less than 3 years and not more than 6 years. Again, then we should find congruence for the sanction regime. The Speaker, assumed.
Yes, the motion has been moved. Yes, Sam.
Mr. Speaker, we associate ourselves with the amendment moved by the majority leader, just to say that this one has been couched as a second-degree felony. And the reason why it's such is that the premises, that's okay, yes. And so between the 3 to 6 years also is fine. So then, Mr. Speaker, once we're in agreement, I think we can just take it as it stands and put a question.
Honorable Muntaka.
What I would hope, since Honorable Sam George has the table for the penalty units, let's hope that we could add it to this. We should leave it to only in prison terms.
Right, that's the point I was trying to make. That you see, we are trying to clamp down on the use of premises, because the premises is where there are new hubs that are festering these things. So if you are arrested for giving or using your premises to this, there is no fine involved. It is custodial, straight.
Honorable Sam, I think this we've had a lot of debate on this, and Honorable Deputy Majority Leader advanced so many angles to it that now the angle of the court decongest the prisons. So we shouldn't just limit ourselves to the custodian sense. So I think we will take the same angle as the previous sanctions.
Mr. Speaker, in the morning when we started, I wasn't here. And that is why I was saying that because I wasn't here, I just wanted to align with what I made them do was misdemeanor. This is second-degree felony. And there's a world of difference. So, Mr. Speaker, that is why I asked that if we did, this is in alignment, then let it stand. Let it stand.
It stands as a second degree.
Absolutely.
Yes.
Speaker, I support the present amendments in toto, except that I want to find clarity from the sponsor of the amendment In line 2, a person who keeps a movable asset, a room, a house, or any other asset. Now, if you use a movable asset and brings in a room or a house is immovable property.
Yes.
So, are we saying that an asset in line 2 could mean a vehicle? For instance, because I want to understand that we are referring to the use of immovable property in this sense. Because a movable asset is not the same as immovable asset. If we can look at that, if we are using both the movable asset as well as immovable assets, then we may have to give that indication in the provision. Yes, but we need to give clarity. There are also other assets. If we can clarify, save that, we are good to go. Thank you very much.
Well. Yes, leader, can you explain that aspect for us? Movable aspect.
Mr. Speaker, if you look at the original spoke about movable or immovable assets. All other assets. And the assets could be movable or immovable. That is why I've pruned it of that further description of movable or immovable. So they are all assets. They are all assets, movable or otherwise.
But leader, I think the clarity ought to be made. Because I don't see the clearance on this. Because if it is movable, and that's what Honorable Fiamopo was saying, vehicles are assets, but they are movable. So if we can construe it to mean that all those assets are part of this, then we have to understand in that angle.
Mr. Speaker, certainly a room is an immovable asset. A house is an immovable asset. Others may be movable assets. Now, the next line is any other asset for purposes. And any other assets includes movable and immovable. Unless you want us to insert those words, any other movable or immovable assets. But it will make it too verbose and will not add value to it. Mr. Speaker, the verbosity will be gargantuan. So let's allow it to be there.
Mr. Speaker, I agree, but we are dealing with a penal legislation. So, like you said, when we have lawyers, we can dance in between some of these things. But I agree that depending on the circumstances, any part of that provision, liability can be fixed. So it's fine.
Well. Honourable members, I will then put the question, and the question is in favour of the proposed amendment by the majority leader on clause 9. On clause 9, all those in favour say aye. Honourable members, I expect you to respond. All those in favour of the proposed amendment to clause 9 say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment is carried. And clause 9 stands part of the bill. Yes.
Speaker,
return to clause 10.
Yes. Speaker, thank you very much. Item number X, clause 10, amendment proposed. Subclause 1, delete and insert the following. A person who publicly and willfully does a grossly indecent act commits a misdemeanor. So move, Mr. Speaker.
Yes.
A person who publicly or willfully does a grossly indecent act commits a misdemeanor. So moved.
members, there is a proposed amendment on clause 10, sub clause 1. Yes, leader.
Mr. Speaker, in the original, the provision is a person who willfully commits a grossly indecent act, a misdemeanor, and liable on summary conviction to a term so and so and so. Why are you deleting the sanction prescribed?
Speaker, I agree with the position of the majority leader. So the further amendment will be this. Instead of deletion, we will be inserting that all the portion will be inserting a person who publicly and willfully does a grossly indecent act, commits a misdemeanor, and then the rest of the sentence will follow. So that we'll maintain the sanction element of the sentence.
Can you come out with the rendition again?
So, yes. So, Speaker, the rendition will be this. A person who publicly and willfully does a grossly indecent act commits a misdemeanor and is liable on summary conviction to a term of imprisonment of no less than 6 months and no more than 1 year. I so move, Mr. Speaker.
Yes, leader.
Speaker, unfortunately, I'm not always around when this bill comes up for consideration. But I want my colleague to revert to clause 5. Duty to report. It provides a person in whose presence an offence is committed under this act shall report the commission of the offence to, and the category of people have been specified. Now, it's not talking about whether it's done publicly or privately. Now, you are saying that it necessarily must be public. Is that, how do you reconcile that with 5?
Now, that is okay.
Honourable Speaker, I'm just going back to the memo of the committee. I'll go there. But the use of publicly, you see, the rationale for this was because they wanted it to reflect the language of Section 278A of Act 29. Because again, this provision is of indecent exposure applies to sexual couples, and so it is to make consistency in this nation with what exists already when it comes to heterosexual couples. Act 29, Section 278A. So that's where the publicly and willfully comes in. Now, to address the issue of Section 5 of Clause 5 that we worked on, Clause 5 talks about a duty to report. But we did some work here in the chamber to realign that duty to report, and said that if a person in whose presence the offence was committed, the person will have to report that act, the commission of the offence, and we listed a number of officials that they have to report. But this is not talking about the person in whose presence it has happened. This is for the offender himself. So, for example, Right Honourable Speaker, if for want of a better example, a person, let me not use the majority leader. I was going to use the majority leader as an example, but let's assume that a person who is heterosexual engages in indecent exposure in public, that person is liable under section 278 of 9 for prosecution. Now, in this case, what we are saying here is, if the person is engaged in an activity that is homosexual in nature, that person is also liable. So once it is done publicly and willfully, this is basically dealing with indecent exposure in public spaces. Because there are some locations in Accra today, Mr. Speaker, if you went there for a drink, the kind of indecent exposure you see between two men and two women in Accra today, this is what this section is trying to deal with. And that's why if you go to 2, you see amorous affection and all of that. Because it is the actions that happen in public. And those are the things, Mr. Speaker, there are places in Accra today I cannot go to again, because those places have become some kind of hive, some kind of activity. So that is what we are dealing with.
Yes.
Speaker, the publicly nature of it is such that we have to determine intent. So that is why it is not disjuncted. It must be publicly done and it must be willful. So this is in respect of the actor, the accused himself or herself. And 5, the duty is imposed on a bystander, who in this case will become a witness to the offense. And the law is fixing liability if you fail. So the failure will then be willful. That is, you saw it, but you willfully refused to report. So the law will fix the liability. So there's some material difference there, Mr. Speaker, with respect to the majority leader. I believe that we can carry it when we get to second consideration can be done. I so.
Very well. So I will put the question. Honourable members, all those in favour of the proposed amendment cross 10, so cross.
Speaker, with all due respect, with the further proposed amendment, I got guidance from majority leader, so I further propose amendment to include the penal provision.
So the question is, all those in favour of the further proposed amendment by the majority leader, say aye. The further proposed amendment is not the original proposed amendment.
Yes, but I made that further proposed amendment, which is guide. It was one that we were leaving that portion out. So I took a cue and.
Well. So, honourable members, I will urge you to follow what is going on, so that it appears we are here, but our minds are out. So, yes, leader.
The Speaker, so for the avoidance of doubts, it is the original as in 10.1 that we are repeating, except to add publicly before willful in line 1.
Very well. So all those in favour of the further proposed amendment, say aye. All those against, say no. Honourable members, the ayes have it. The further proposed amendment to cross 10, so cross 1 is carried. We move to sub cross 2. Cross 10, sub cross 2 by the chairman.
Speaker, thank you very much. Item number XI cross 10, amendment proposed. Sub cross 2, paragraph A, line 1, delete amorous and insert romantic. I so moved. And Speaker, let me add Martin Kosa to participate in the process. Thank you very much.
Honourable members, I want to urge members in the chamber to follow what is going on. I'm not mentioning anybody's name. I'm just pleading with members to follow what is going on. So, sub cross 2 of cross 10, the proposed amendment has been made. I'll put the question. And the question, all those in favor of the proposed amendment to cross 10 sub cross 2, say aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. We turn to cross 10, sub cross 2, paragraph B, line 1. Yes.
Speaker, thank you very much. Item number XII cross 10 amendment proposed. Sub cross 2, paragraph B, line 1. Delete amorous and insert romantic. I so move. Thank you very much.
Honorable proposed amendment to delete amorous and insert romantic. The question is, all those in favor of the proposed amendment say aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. We move to 10 cross 2, paragraph C, line 2, by leader.
Speaker, I wanted us to delete the words assign so that C would read, for purpose section, grossly indecent act means C, intentional cross-dressing to portray that the person is of a gender different from the gender assigned at birth with intent to engage in an act created under this act. So, Mr. Speaker, that was my concern, that we should delete the word assigned, because gender is not an assignment by people. It's natural at birth. It doesn't need to be assigned by anybody that you are a male or a female. Unless maybe it's a term of the industry practitioners. I don't know. Say maybe of medical practitioners. I don't know. But that being the case, if that is not the case, then I would think that if we deleted assigned, it will serve a much better purpose.
Very well. Yes.
Mr. Speaker, we are aligned with the proposed amendment, because you see, what it really does is, in some jurisdictions, what is happening now is people are actually assigning at birth wrong genders. So there are instances where parents have given birth to a boy. You can tell this is a boy, but because the parent wants a girl, assigns that. Honorable Napo, I'm not pointing at you. You are not the one who has assigned. I know you're a medical doctor, but you don't assign sex. So rest easy. But so I'm happy that we take out the assignment and just leave it a gender at birth, so that is what everybody knows. So we are on all fours with the leader.
Very well. So, honorable members, I'll put the question. And the question is, all those in favor of the proposed amendment by the majority leader to cross 10, sub cross 2, paragraph C, aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. Leader, the drafter is advising that based on the position that has been adequately proposed or given out by some judge with respect to assign, trying to explain assign, we want to directives that wherever we see assign in respect of the bill, we can delete it. I don't know whether it makes sense, because it might not only be reflecting this particular clause, it might happen in other areas. So if the directive, the advice of the drafter is...
Mr. Speaker, I think we must look at the context. We must look at the context of usage. But contextually, if it aligns with what you have said, the proposal, then it must fall. But we must be careful that it doesn't have universal when you are not even there. So we must look at the context.
Very well. So let me put the tie cross of clause 10. So all those in favor that clause 10 as variously amended stands part of the bill, say aye. All those against say no. Honourable members, the ayes have it. Clause 10 as variously amended stands part of the bill.
Speaker.
Yes, leader.
Just wanted to point out that this is a serious bill that you are making requires all seriousness. Let nobody, by what you have done, in C, say intentional cross-dressing to portray that the person is of a gender different from the assigned at birth, the gender at birth, with the intent to engage in prohibited activities. Let nobody construe what you have done here to maybe judge what happens in the drama that we all watch. A man dressed up in female gaps, pretending that he's a female and diminishing the voice to mimic the voice female for, comical reasons. And then he enters into a relation on stage with somebody, and then we want to apply this. The Speaker, it has no such application. It must be for the record. It has no such application.
Mr. Speaker, the wisdom in the submission of the leader is very apt, because it has been one of the clauses that has been widely debated in the public space in Ghana, to suggest that as soon as you are a man and you are engaged in a stage play and you are dressed as a woman, or we have women who act as men in stage plays, automatically you fall in foul of this bill. Because the operational phrase here is that to engage in an act prohibited under this act. So in the play, if in the play one of our beautiful ladies at table is made to act as a man, and she is marrying a woman in a stage play, the intent is not to commit an act that has been prohibited under this bill that we are working on, so that the public and the media carry it out that we are not saying that a man cannot dress as a woman, or a woman dress or act as a man. It is only what the intent that needs to be established. Thank you very much, Leader, and thank you very much, Speaker.
Very well. Do we go on?
Yes.
Very well.
Void
So
marriage.
Return to clause 11. There is a proposed amendment to subclause 1C by the majority leader.
Speaker, 11, I think my amendment is in C. One C, that we should add the following. Yes, there's 1A and B. A marriage entered into by the following persons is void: persons same sex, or a person who has undergone gender or sex reassignment. Then the C that I'm adding is a person who has undergone any other procedure that is intended to create sexual category other than the sexual category of the person at birth, except in the case of correcting a biological abnormality, including intersex.
Yes, honorable members, the proposed amendment is before the House. I will put the question. If nobody has any. So the question is, all those in favor of the proposed amendment to clause 11, so clause 1, say aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. We turn to clause 12, amendment proposed by the chairman.
Vice Honorable Speaker, amendment proposed by Chairman is to delete clause 12. Thank you.
Yes.
Mr. Speaker, I have the rationale. I think the mover would read the rationale.
You are saying we should delete the entire clause 12?
That's what the committee proposed, that it appears it is a repetition of clause 10. 13. Clause 13.
Mr. Speaker, that rationale doesn't hold. And as sponsors, we stated that to the committee chair. Because when you read the bill, clause 12 is dealing with prohibition of propaganda of, promotion of, and advocacy for activities prohibited under this act. Clause 13 is dealing with...
Sam, hold on. Honorable, are you a member of the committee? No, I mean, Honorable, technically we need a member of the committee to move the amendment. If you are not a member, then it's...
Yes. Speaker, apologies. Item number XV, amendment proposed. Delete. Speaker, the rationale is simply that appears to be a repetition of clause 13. So it amounts to surplusage. So we need to delete it. Please submit it.
Well, there is a proposed amendment to delete clause 12. Yes, Honorable Sam George.
Mr. Speaker, as sponsors, we are opposed to deleting clause 12. Reason being, the rationale given, it doesn't hold, because 12 says, for prohibition of propaganda of, promotion of, and advocacy for activities prohibited under this act. But 13 is prohibition of propaganda of, promotion of, and advocacy for activities directed at a child. They are two different things. And so, Mr. Speaker, we have consequential amendments, other amendments that have been proposed that we think would deal with the issues that were raised at the committee in 12.2, where you talk about sympathy and a change of public opinion. Those things, I think we have other amendments to deal with, but to hold, which I think hold a section or a clause that deals with promotion of the activity in general. Because, Mr. Speaker, if you look at, in the case of heterosexuals, there is an offense when you engage in heterosexual sex for sale, which we call prostitution. But if it is targeted at trafficking a child, completely different offense from if you are a pimp trafficking a grown woman. They are treated separately by our criminal. So in this case, anything that is aimed at a child should be distinguished from anything that is targeted at people who are not children. And that's why I think that 12 and 13 should stand independent of each other. And let's look at the amendments there. And so I would plead with the mover of the motion to withdraw so that we can consider the other motions.
Chairman.
Yes, leader.
Mr. Speaker, I agree that the 12 is generic. 12 is generic, and 13 is specific, targeted against offenders who are abusing children. In other words, child abuse. So 12, which is generic, can be distinguished from 13. So I don't really see why we would want to delete 12. So that is stand, and if there are amendments, we can engage in that.
Speaker withdrawn.
Thank you.
Very well. So if it is withdrawn, then let's move to Sam George, your amendment, proposed amendment to subclause 2.
Thank you, Honorable Speaker. XV on page 8, clause 12. Amendment proposed. Subclause 2, paragraph A. Delete sympathy for. So that it will now read, a person who engages in or participates in an activity that promotes or supports an act prohibited under this act. Instead of sympathy for an act. Because we're in the committee, the conversation was that sympathy for was subjective and not an objective test, which we agree with. And so the proposal is to delete sympathy for in subclause 2, paragraph A.
Honourable members, I'll then put the question, and the question is, all those in favor of the proposed amendment to subclause 2 of 12, say aye. All those against, say no. Honourable members, the ayes have it. The proposed amendment is carried. We move to subclause 2, paragraph B. Sam George.
Mr. Speaker, even though the value is the same, okay, I was going to suggest that for A, we delete act, act with small a, and rather insert activity. I've just noticed that the preambular bears that language, activity. So perhaps we may allow it to stand. I was going to suggest that we do we delete act, that an activity prohibited under this act. But the preambular has that word. It has a word. So maybe we can leave it as it is.
Yes.
Okay, so if I understand, then we leave it as it is. Okay, so then I'll move XVII, clause 12. Amendment proposed, subclause 2, paragraph B. Delete a change of and insert activities aimed at changing. But again, I am guided by what has just been raised by the Honorable Chairman Bonsu, because it will then read a person who supports, who engages in or participates in an activity that promotes us activities aimed at changing public opinion towards an act prohibited under this act. It sounds like a mouthful. I don't know, if, Honorable Chair, if there is any other word we can use in this case, any other phrase, instead of activities aimed at changing. Because there's activity at the top there already.
Speaker, you want to say something?
Or can I suggest action? Action aimed at changing. So to read, a person engages in or participates in an activity that promotes or supports action aimed at changing opinion. I don't know if action sits well there.
So I'll put the question.
Mr. Speaker, I was thinking of, in that case, going to the preamble to change the word activity, and then rather make that one an act, so that when we come to A, it will read an activity, right, prohibited under this act, and then we can use the same word activity in B, right.
So then we can change the preamble to read, a person who engages in, participates in, promotes or supports, and then A will be activities prohibited or an activity prohibited act, and then B will be activities aimed at changing public opinion. So to read, a person who engages in, participates in, promotes or supports will be the new consequential amendment. If that sits well with the Honorable Majority Leader and Honorable Matthew Poku Prempeh, then I could do the full rendition for both XVI and XVI. Honorable Majority Leader, I don't know if that works. The preamble, rephrasing the preamble to say, a person who engages in, participates in, promotes or supports, so that we can then introduce activities in the A and B.
Pluralize it, just being the singular way. The person who engages in, participates in, promotes, supports an activity prohibited under this act, right? Or an activity aimed at changing public opinion, right?
So give me the rendition.
So, Mr. Speaker, with your permission, we will go back to XVI. And the amendment now will be delete subclause 2, not paragraph, subclause 2. Delete an activity that. So the amendment is subclause 2, clause 12, subclause 2, delete an activity that. And then subclause 2, paragraph A, delete sympathy for and insert an activity. So it will be subclause 2, paragraph A, delete sympathy for an act and insert an activity. So it will then read, a person who engages in, participates in, promotes or supports an activity prohibited under this act. I so move, Mr. Speaker.
Very well. Can't we read by paragraph B?
Mr. Speaker, the way my friends has reconstructed this seems to change the meaning, the original meaning. So let it read: a person who engages in or who engages in or participates in an activity that promotes or supports an act prohibited under this act. They were concerned about the usage of the word act and act as in law, or an act aimed at changing public opinion, right? In other words, you promote or support an act aimed at changing public opinion towards towards an act prohibited under this act. Give us time. Give us time to.
Can we stand it down?
Let's stand it down and work on it.
Okay, then. So, leader, then I'm bringing consideration to a close. I'm bringing the consideration. If you have any other thing that you...
Yes, we can respectfully, if we can go to the, let's just step the 12 down and see whether we can go to 2:30. If we can go to 2:30, that is if it meets your convenience. I don't know how your physical constitution.
You don't have any other thing to do.
So we can go to 30. We can stand the 12 down.
So are you standing down all the entire 12 or only
12? Let's stand the 12 down.
Entire 12.
Yes.
Very well. So let's turn to 13.
Prohibition of propaganda, promotion of, and advocacy for activities directed at.
There is a proposed amendment by our leader to clause 13 subclause 1, paragraph A. Yes, leader.
Speaker, the are all in single, and 13.1 provides a person who through media, I'm just saying that we can, using the singular form of the media, go through a medium instead of media, technological platform, technological account, or any other means produces, markets, broadcasts, disseminates, publishes, or distributes. So just to put it in singularity, I think we can leave it to the drafters. But just using the singular.
Okay, let me welcome Honorable Enyafo.
Thank you for welcoming me, and thank you for giving me the opportunity. Mr. Speaker, in drafting, you always draft in singular. So the Honorable Leader is right. So I support his amendment.
So, Honorable Member, the question is, all those in favor of the proposed amendment to clause 13, subclause 1, say aye. All those against say no. Honorable Member, the ayes have it. The proposed amendment is carried. We move to clause 13, subclause 1, para D, line 2, by Honorable Osei Mensa. Yes, leader.
I thought it's not coming out to me now, but I thought I'd seen 12 years somewhere, and I was just looking at how to do a reconciliation. That is why I proposed the deletion of 10 years and the insertion of 12 years. I think I've seen it somewhere, and that is why I brought it there. Maybe the sponsors could bail me out.
No, the sponsors, Honorable Sam George, where do you have the 12 years?
I thought I'd seen 12 years somewhere, so I was looking at reconciling. That is why I said we should delete the 10 and insert 12. But it's not coming to me now.
Honorable Speaker, I don't remember seeing 12 years anywhere in the bill. It's been 10 years. As far as the draft of the bill was sponsored, the maximum had been 10 years. So, except the majority leader wants us to raise the ceiling to 12 years, we can have a conversation on that. But 10 years was the ceiling we had placed on it. But in his wisdom, in the number of years he spent in this parliament, if you think that we should do 12, we are open to it. But 10 years is actually what we had put there.
Mr. Speaker, my only reason for proposing the 12 years is that I thought I had seen 12 years somewhere. And I thought for purposes of consistency, we should have it as 12 years. But if it doesn't exist anywhere, then let's abandon that. So I can abandon that.
So you abandon XIX is abandoned. So we move to XX, cross 13, sub cross 2. Yes, leader. 13. That's XX.
Speaker, sub cross 2. The opening phrase where a person is convicted, the owner of the medium, is just like what I did earlier. The owner of the medium, technological platform or technological or any other means on which the material is produced. We are limiting it to the media, technological platform or technological account. There could be some other means, and that is why I've inserted after technological account the words or any other means. So the first one is to synchronize with what I did earlier. And then, Mr. Speaker, the last one is line 4. I said we should delete broadcasting. Mr. Speaker, I thought broadcast, the past of broadcast is still broadcast, not broadcasting. So, the reason why I'm saying that we should delete broadcasting and instead broadcast.
Very well. You have something to say? You support? Very well. So I'll put the question. All those in favor of the proposed amendment XX, that is cross 13, say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment is carried. We move to XXI. XXI. Cross 13, so cross 3. Leader.
Speaker, 13.3, sub 3, paragraph A, line 1. After subsection 1,
item number XXII. My ranking is here, but I believe that Clause 13, amendment proposed, subclause 3, paragraph A, line 2, delete 3 and 4. 3, comma 4. Humbly submitted, Mr. Speaker.
Honourable members, the proposed amendment has been made. Do I put a question?
The rationale for this was that the committee tried to realign this clause with the cybersecurity legislation, that the provisions in the cybersecurity law, because there's a similar thing in the cybersecurity law that was passed, I think, Act 1078 of 2020. That's 1038 of 2020. And so that's why we are just doing alignments to make sure that it aligns with the provisions in there. That's why we're deleting 3 and 4.
Do I put a question? Leader, you want to say something?
Honorable Dr. Biprempe was seriously distracting me. Mr. Speaker, they say it's for purpose of realignment. Realignment with what?
Speaker, thank you very much. Speaker, there's a provision in Act 38, 2020. And so the view of the committee is that 3 and 4 should be deleted to align with the provision as contained in 1038. Because if we allow 3 and 4 to stay within the legislation as it is, it conflicts with the provision in Act 1038, which is a legislation in existence. So we agreed as a committee to take it out.
Mr. Speaker, respectfully, I just consulted the drafting unit. And you see, these meetings were held over a year ago. And so the effect of time. The understanding is these proposals were made with the intent that the committee was deleting clause 12. And so now that we have maintained clause 12, most of these amendments, because they will stand in conflict with clause 12. So I will urge the chairman to withdraw them, because then it will now create conflicts.
We just stepped down clause 12. So we didn't.
We did not step down clause 12. You know, the chairman of the committee had proposed us stepping down clause 12 with the intent of, with the rationale, deleting clause 12 with the rationale that it was the same as 13. And we made the argument on the floor here that 12 was generic, so the words used by the majority leader, and 13 was specific to children. So all of these consequential amendments to 13 that we see from the chairman were with the premise that 12 had been deleted. But now that we have, as a house, decided to maintain 12, 13, these amendments will no longer hold. They will be moot. So it will be important that the chairman of the committee reconsiders those amendments. And so,
is it the entire 13?
A number of the amendments that were proposed by the chairman in 13 were on the basis of the deletion of 12.
Okay. Very well. So,
Speaker, my brother Sam George ought not to do this to me on the floor of engagements by the side. Be it as it may. Mr. Speaker, now having been properly seized with the matter means that the amendments as proposed in item number XXII, XXIII, XXV and XXVI, all the way through will have to be withdrawn. Will have to be withdrawn consequentially. But I'll do so serially. I'll do so serially in the sequence and see where they are germane, will carry them, where they are not. So, but in this case, I'm withdrawing this one. Yes, in this case, I'm withdrawing this one. Thank you.
Mr. Speaker, just so that the records bear me out, I intended no malice to the honourable member for South Dan, the honourable Roxton Eche Nelson Nafiameko, and so I plead that the records bear that I bear him no malice whatsoever.
Very well. So we then tend to cross XXIII by the chairman. Is that one to also withdrawn?
Yes. Withdraw accordingly, Mr. Speaker.
Okay, very well. Then we move to XXIV. XXIV by the leader.
Mr. Speaker, 13(3) provides an unincorporated body of persons is convicted where an unincorporated person is convicted under subsection 1, 2, 3, or 4 of this section. The principal officers of the body of persons, whatever name called, shall be deemed to have also committed the offense. Mr. Speaker, that phraseology, whatever name called, is really superfluous. It doesn't add any value to it. So it is that I'm calling for the deletion of that construct, whatever name called. So it should just read, where an unincorporated body of persons is convicted under subsection 1, 2, 3, or 4 of this section. The principal officers of the body of persons shall be to have also committed offense. As simple as that. Speaker, I so move.
Honourable members, I'll put the question. And the question is, all those in favor of the proposed amendment by the leader say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment is carried. So we turn to XXV by the chairman. Is this one too withdrawn?
Speaker, that is so.
Very well.
Yes, because
then we turn to XXVI. XXVI. Is this one too withdrawn?
No, it's not withdrawn. It is to that's clause 13, sub clause 4, definition of technological account, line 1, delete Facebook. That is with a small letter. And insert. No, we deleted the so we are here now. So it's simply put, we are just giving those domain names initial capitals, initial caps. So Facebook, small letter will now become Facebook with an initial capital. And Twitter, yes. So yes, Twitter, also known as X. I think the legislation should reflect that. We'll keep Twitter, but we are enlarging.
It's not X. So it's not X.
You see, the legislation is to be implemented. and I agree that it has recently been named X. So, for the sake of giving, in my humble view, Mr. Speaker, we should maintain Twitter, but simply add also known as X. No, that's the law.
It's not X.
Yes.
Okay, Speaker. Mr. Speaker, Twitter, now known as X. Or X, formerly known as.
Because this is the time we are making the law.
Yes.
So I think if we don't call it Twitter anymore, we don't have Twitter. So, I mean, the law is in respect of the time.
Mr. Speaker, you see, X is a very notorious symbol. No, X is a very notorious symbol. So unless we are saying that we'll go into the interpretation and define it, we don't want to do that. So the law is to be implemented, and in legislation, you make the implementation easier for people. So I'll be happy if we can let Twitter reflect in describing X. So X, formerly known as Twitter, it doesn't hurt the legislation; it enhances it.
Very well.
Thank you very much.
Yes, leader, do you have anything?
Mr. Speaker, I was just going through the bill to see if it has been applied anywhere. It's not. It's not been applied anywhere. And so I don't see as after X referring to its former name. Because it's for now, this legislation is for now. And now it is X. Now it is X. So we don't need it. We don't need the former name for anything. But he's saying just for the avoidance of doubt. Maybe you can live with it, but it doesn't add value to it in any way. So we can just say X.
Mr. Speaker, I associate with the position of the majority leader, but I still get the sense of what the Honorable Roxanne Dafiameko is talking about.
Position.
My position will be that we should use X, formerly known as Twitter, just for the avoidance of any doubt.
Very well. So I'll put the question. And the question is in favor.
Mr. Speaker, this law will not take retrospective effect. So why do we refer to X formerly known as? The law will always take prospective effect. So once it is now X, we need to use the word X.
Yes. Very well.
Speaker, I laid the foundation by saying that X is a notorious symbol. It's very notorious. It's not a symbol that is used in a lot of mathematical formulas. That is what I'm saying. Having become a domain name, we want to make the implementation easier by enlarging the meaning, the law. It doesn't hurt it. I see my leader vehemently shaking his head in disagreement. So I concede our battle.
So X formally S implicita. Very well. So I'll put the question. All those in favor of the proposed amendment say aye. All those against say no. Not members, the ayes have it. The proposed amendment to XSVI, that is clause 13, sub clause 4, is carried. Yes.
Yeah, before we move to the next amendment, I just want to draw the attention of the drafters to clause 13(4). For the purposes of this section, we have consequentially amended it to medium.
Yes.
Yes, yes.
The leader has amended. Yes. So we tend to.
No, Speaker, and it must also follow in the second line of owner. So consequentially in that phrase, everywhere media is seen, because owner means the legal owner operator of the media. I should read medium.
We tend to question
Clause.
across S, X, V, I by the chairman.
Speaker, thank you. Item number XSV clause 13. Speaker, it's a repetition. So, yes, it's a repetition of item number XXVI.
Okay. Okay.
Thank you.
So we tend to.
Mr. Speaker, it is not a repetition such that we are skipping. The amendment is repetitive because in XXVI you were talking about technological accounts, and that is where you did those changes. In XXVII you are talking of technological platform. So it is the same justification, but we need to carry the amendment because one is about technological accounts, the other is about technological platform. But it's the same thing. So the question still needs.
Very well. So the question is, all those in favor of the proposed amendment to XXVII, that's clause 13, so clause 4, say aye. All those against say no. Honorable members, the ayes have it. The proposed amendment is carried. We turn to XSVIII. XXVIII by the majority leader.
Speaker, I think it's we in 13 we use the words medium, technological platform, technological accounts, and we came to 4 to define these words. And in much the same way, B also uses the words electronic device, internet service, and thought that it is important for just the avoidance of doubt to bring that clarity to bear on that. That is why what is happening here has been done. Out of 13, 14 to add the meanings of electronic device and internet service. The Speaker associates.
Yes. So I'll put the question. And the question, all those in favor of the proposed amendment, say aye. All those against, say no. Honorable members, the ayes have it. The proposed amendment is carried. We turn to XXIX. XXIX. This is the proposed amendment by the majority leader. Clause 13, subclause 4,
13.
XXIX.
The Speaker is it has to do with the interpretation of owner. Line 2. For owner. Owner means the the legal owner or operator of the medium technological platform, technological account, and where the medium technological platform or technological account is owned by more than one person, every joint owner. Speaker, that is where I'm seeking to amend. As in line 2, after account, we insert or any other means, as we did earlier. And in line 3, after account, insert or any other means. Again, just to synchronize with what we did earlier.
Yes. Honourable members, the proposed amendment by the majority leader. The question is, all those in favor of the proposed amendment say aye. All those against say no. Honourable members, the ayes have it. The proposed amendment is carried. Let me now put the entire clause 13 as variously amended. And the question is, all those in favor that clause 13 as variously amended stands part of the bill, say aye. All those against say no. Honourable members, the ayes have it. This amendment to clause 13 as variously amended stand part of the bill. And this is where we bring consideration to a close. Yes, leadership, let me come to you.
Mr. Speaker, especially if we can go back to item 7. Item 7, present papers.
Honourable members, let me bring you back to page 2. Page 2, item listed 7. Item listed 7, page 2, presentation of papers. So, honourable members, please. So, 7A by the chairman of the Finance Committee.
Speaker, the Finance Committee is meeting and they've not given me any indication that they finished with this. So let's start those ones now. That is the A, Roman number 1 and number 2. And then we come to B.
Yes. So let's come to B by the chairman of the Committee on Environment, Science and Technology.
Report of the Committee on Environment, Science and Technology on the Environmental Protection Bill 2023.
Honourable members, the report has been duly presented. It is for distribution to honourable members. Let's now turn to the chairman of the Energy, Mines and Energy Committee.
Mr. Speaker, I'm aware that this one has been done, and maybe I could present the report on behalf of the chairman. That is part of C, and then D, Roman number 1, not Roman number 2. if we can do just two, and then after that we can take an adjournment.
Leave granted.
Report of the Committee on Mines and Energy on the determination of the Agency of Energy Commission Bill 2023.
Honorable members, the report has been duly presented. It is for distribution to honorable members. Now, DI.
Report of the Committee on Gender and Children on the determination of the Agency of the Affirmative Action Gender Equality Bill 2023.
Honorable members, the report has been duly presented. It is for distribution to honorable members. Yes, leader.
Speaker, let me just sound that the referral of the amendment bill to the Committee on Mines and Energy was done because Parliament was about to adjourn sine die. So, and it was to really avoid the Gazette period of 14 days before its introduction into the House. Now that that determination has been made by the committee, they have to go and do the gazetting, and the committee to also do the considering and report to us as soon as practicable. Mr. Speaker, it should not be understood that this bill is to be considered in one day. It was purely to avoid the Gazette period of 14 days. That is why they came to be late. That is in respect of both the C, that is the Action Bill, and the Affirmative Action Bill. So, the Speaker, today that they be late, they should ensure that they are gazetted today at the close of day. Yes, because once the determination is made, it paves the way for it to be gazetted. And especially with the Affirmative Action Bill. So, Speaker, next week we need to do the consideration of that bill. So the committee should work seriously on that. Thank you very much.
Very well. But I think we don't have any of the members of the Energy Committee here. Yes, the Vice Deputy Ranking. Yes.
Mr. Speaker, with a short response to the leader, they are now in the report of the Committee on Mines and Energy on the determination of the Agency of the Energy Commission Amendment Bill 2023. Now that the report is going to be distributed for a determination as to whether it should be, it's a different one. Okay. Once it is a different one.
Very well. So, honorable member, I hope you've taken notice of the leader. Yes, sir.
Yes, Mr. Speaker.
Very well. So, leadership, I'll come to you once again.
Speaker, as I indicated, we've done a considerable job, and I beg to move that the House do now take an adjournment until 10 o'clock in the tomorrow. I so move.
Yes.
Mr. Speaker, I second the motion for adjournment.
Honorable members, now we are supposed to sit for 5 hours, and per our standing orders, the 5 hours is supposed to end by 3 p.m. The time is 2:30 p.m. So the motion that has been moved is right. So the question is, all those in favor of the motion that has been seconded by the minority, say aye. All those against, say no. Honorable members, the ayes have it. The motion is carried. House is accordingly adjourned to tomorrow, 10 o'clock in the forenoon. The House stands adjourned.